Inclusive Justice, Global Strategies for Dismantling Legal Barriers for Women and Girls, the USA Experience. Dismantling, demolishing, and totally obliterating barriers to inclusive justice for women and girls in the United States requires a multi-pronged approach. I would want to speak to these concerns and interests under three main headings. I would want to address, first of all, the deep-seated constitutional gaps. Secondly, reforming the criminal justice system. And thirdly, expanding community-based support. So here goes. Number one, constitutional and legal reforms. In this wise, the ratification of the Equal Rights Amendment, ERA, comes into fore. ERA is a proposed amendment to the US Constitution designed to guarantee equal rights for all citizens, regardless of sex, prohibiting discrimination in areas like employment, property, and divorce. First introduced in 1923, it passed Congress in 1972, but missed ratification deadlines. While proponents argue that it was ratified by 38 states as of 2020 and is now the 28th Amendment, legal challenges regarding deadlines and rescissions persists. Enshrining the Equal Rights Amendment would provide permanent constitutional guarantee against sex discrimination. It would replace the current reliance on piecemeal legislation that can be weakened or repealed. Then there's the strengthening of federal protections. In this wise, what firstly readily comes to mind is the waiver, the Violence Against Women's Act, VAWA, a 1994 US federal law that strengthens legal responses to domestic violence, sexual assault, dating violence, and stalking. It enables victims, regardless of gender, to seek safety through specialized immigration relief, self-petitions for green cards, housing protection, and support services, including those for abused immigrant spouses and children. Reauthorizing and expanding the Violence Against Women's Act, VAWA, is essential for maintaining the infrastructure for survival supports and holding perpetrators accountable. Then there's the closing of legal loopholes. Courts in the United States often interpret factors other than sex broadly in pay discrimination cases. Legal reforms like Paycheck Fairness Act are needed to close these loopholes and ensure equal pay for equal work. The Paycheck Fairness Act is a proposed United States legislation designed to update the Equal Pay Act of 1963, aiming to close the gender wage gap by strengthening anti-discrimination laws, prohibiting salary history inquiries, enhancing penalties for violations, and protecting employees who discuss their wages. Then there's the protection of educational equity, protecting educational equity, maintaining and strengthening Title IX protections is critical to ensuring girls can attend school free from sexual harassment and discrimination. Title IX is a 1972 federal civil rights law, which prohibits sex-based discrimination in any school, college, or education program that receives federal funding. It ensures equal opportunity in academics and athletics, regardless of gender, while also requiring schools to address sexual harassment, sexual violence, and pregnancy discrimination. The next category of reforms that I'll be discussing is the criminal and juvenile justice system reformations. This necessarily would involve the adoption of gender responsive approaches. The Women in Criminal Justice Reform Act, in this wise, aims to mandate gender responsive training for officers and ensure incarcerated women have access to healthcare specific to their needs. Then there's the prioritization of diversion over incarceration. Using incarceration only as a last resort, particularly for status offenses like truancy or running away, prevents the unnecessary criminalization of girls. Then there's investing in community reintegration. In this wise, expanding programs that offer alternatives to incarceration and supporting community-based healing helps interrupt cycles of trauma and system involvement. And then we have the increased representation, promoting diversity in the judiciary and law firms would ensure the justice system better reflects the society it serves and enhance its legitimacy and fairness. The third category of reforms that I'll be discussing has to do with community-based and intersectional strategies. Community-based and intersectional strategies. This involves support survivor-centered services. Providing free or low-cost legal aid, mental health services, and safe spaces which allow survivors to seek justice without fear of financial ruin or retaliation. Then there's the aspect of address intersecting barriers. Programs like Girls of Color Initiative and the U.S. Gender and Disability Justice Alliance focus on specific needs of women and girls facing multiple layers of oppression, such as racism and ableism. The Miss Foundation's Girls of Color Initiative, COSI, began in the late 2018 as a national initiative in this wise, centering girls of color living at the intersection of multiple systems of oppression. Then there's the engaging men and women, men and boys, engagement of men and boys. Successful justice initiatives increasingly involve men and boys as allies to challenge harmful gender norms and prevent violence at its roots. A shining illustration of this is the International Bar Association, IBA Male Champions for Change, an initiative within the IBA Women Lawyers Committee featuring a core of 10 to 20 male legal leaders globally. These ambassadors are committed to promoting gender equity, acting as a sounding board for Women Lawyers Committee initiatives, and advocating for the advancement of women within the legal profession. Then there's the aspect of promoting legal literacy. Community programs that lead women and girls, that teach women and girls about their rights, empower them naturally to navigate complex legal systems and advocate for themselves. Specific federal bills currently in Congress There's several of these key federal bills that have been introduced or reauthorized in the current 119th Congress. That's the 2025 to 2026 Congress, to dismantle systematic barriers for women and girls. This includes justice and safety bills, for example, the Protect Black Women and Girls Act, HR 3974, which establishes an interagency task force to examine and mitigate harms against Black women and girls in education, in healthcare, and the justice system. Then there's VAWA, which was talked about earlier on, Violence Against Women Reauthorization. While reauthorized through 2027, ongoing funding and enhancement focus on legal aid, restorative practices, and housing protections for survivors. Then there's the Save Our Souls, Save Our Girls, Save Our Souls, Save Our Girls from Sex Trafficking Act, HR 6919, introduced in December 2025 to bolster federal efforts against trafficking and exploitation of young girls. Then there are the sets of economic and workplace equality bills, the Paycheck Fairness Act, the Equality Act, Be Heard in the Workplace Act. Then there's the Constitutional and Social Protection Bills, the Equal Rights Amendment, which we spoke about earlier, the Women's Health Protection Act. So in the current 119th Congress, the legislative status of these key bills reflects their early stages in the federal process, with most currently under review by specialized committees. So, in conclusion, dismantling barriers to effective access to justice for women and girls in the United States is a marathon, not a sprint. While the legislative landscape of the 119th Congress shows a clear push for institutional change, from the Equal Rights Amendment to the Paycheck Fairness Act, the true measure of progress lies in moving these bills from out of committee and into law. On the whole, achieving enduring inclusive justice requires a pincer movement, high-level policy reform to fix the system's architecture, paired with community-led initiatives that protect women and girls on the ground. As long as legal loopholes and systematic biases remain, the pursuit of equity must continue. Thank you for listening.